The United States Supreme Court hands down its decision about when you can be prosecuted for threatening speech online. The justices say it's enough for prosecutors to show that a person's speech was reckless, even if it wasn't deliberately threatening.
The Colorado case the High Court was considering didn't meet the bar, so the conviction was overturned. But the question we're digging into here tonight is, what impact could this decision have on the trial of a Cape Coral boy accused of making threats? Wink News investigative reporter Celine MacArthur breaks down the decision and what it could mean for Daniel Marquez.
Constitutional law and public safety experts tell me they're not surprised by the U.S. Supreme Court's decision, and they do believe it'll make it harder for the local state attorney's office to prosecute Daniel Marquez. Let's take a look at the case the Supreme Court ruled on. Counterman v. Colorado. This man was sent to prison in 2017 for stalking this woman through Facebook Messenger for years. The woman said those messages scared her. Billy Ray Counterman said he didn't intend to threaten her and was exercising free speech. His attorney also said Counterman suffered from mental health issues, which prevented him from understanding the impact his messages were having on that woman. The Supreme Court overturned Counterman's conviction in a 7-2 ruling. Associate Justice Elena Kagan explained why. She wrote in part, quote, "The question presented is whether the First Amendment still requires proof that the defendant had some subjective understanding of the threatening nature of his statements. We hold that it does, but that a mental state of recklessness is sufficient. The state must show that the defendant consciously disregarded a substantial risk that his communications would be viewed as threatening violence. The state need not prove any more demanding form of subjective intent to threaten another." Professor Larissa Lidsky from the University of Florida Levin College of Law predicted this outcome a week ago.
But I expect they're going to require at least recklessness.
Justice Kagan very carefully defines it as conscious disregard of a substantial risk that it will be perceived as a threat.
Lidsky believes Daniel should have never been charged with a felony.
I'm just shocked that this case is continuing, and the effect on the life of this young man. I don't think this child should be convicted on this, at best, ambiguous text.
In May of 2022, Daniel sent his 10-year-old friend texts he described as a joke about a scam involving money and guns, followed by a reference to a school event. Sheriff Carmine Marcino said he, quote, felt the 10-year-old was really texting a school threat. Daniel was locked up and charged with a second-degree felony. Marcino won't say any more about the case, and to this day, Daniel tells me he doesn't understand why he's in trouble.
I never did anything wrong.
Lidsky explains why the Supreme Court decision should further compel Judge Carolyn Swift to dismiss the charge against Daniel.
You're going to have to look at the intent standard they set and look at the fact that this is a 10-year-old testifying he meant it as a joke, and that should mean he's absolved of responsibility for this, that it's not going to be convicted as a felony. People need to be outraged by this and demand of their public officials that we use our criminal justice resources for serious crimes and not to prosecute 10-year-olds who did something maybe ill-considered and stupid.
We'll see what happens at trial in July, and I will be there. If you want to weigh in, email me at the address at the bottom of your screen. I'm Celine MacArthur, Wink News.